reason why you filed the affidavit. Could you come clear or clarify why you swore this affidavit, referring to paragraph 11?
Your Honor, that is the way I understood it, until I was made to understand that I had to understand other things of the Senate and other court matters. Because as far as I'm concerned, Your Honor, that paragraph summarizes why that I make this affidavit in my capacity as a medical expert, not a legal expert, in adult cardiology, to assist this honorable court in establishing that the first petitioner was duly admitted to hospital on the date in question, and I went to treatment. That was my understanding.
And you had earlier confirmed that the contents of your affidavit were true?
Completely.
To the best of your knowledge?
Completely. And I took an oath on that.
Just to clarify a few issues that have propped up during cross-examination, and I will go back to paragraph 4 of your affidavit, and I'll be direct this time round because it cropped up. Is there any admission issues in paragraph 4?
None at all.
Thank you. So at 3 p.m. on 17th of October 2024, what exactly happened?
At around 3 p.m. is the word. Approximately is the word.
Yes.
If you want to know the exact time, it was 3:25. I have it.
What happened?
At around that time is when the petitioner arrived in hospital.
Thank you.
We took him in. We started the normal thing that we do for history taking his weight, blood pressure, and such. At that time, if you allow me to explain, is the time we start now the admission process.
Thank you.
And admission is a process, not an instant. And as we are doing those things, the accountants asking who is going to pay for this, blah, blah. And when they are ready, then they fix on the computer, this man is now admitted.
So when was he admitted?
According to our document here, 4:18 p.m. That is when the actual documentation of admissions were completed. These are technical details of timing and writing. Before that time, we are still seeing the client. We are doing the necessary things, but he's technically not admitted because the accountants have not allowed us to do that.
Thank you. I'll refer you to page 1 of 4 of the discharge summary. And on the top, the patient name is Mr. RG. Who is RG?
You know, Your Honor, if you come to hospital and you are an ordinary citizen, we put your full names and all your other names. There are clients we don't put names on record.
My Lord, we still object. That evidence is extrinsic to the record. It is inadmissible. And my good colleague here knows that question is also impermissible.
The question was actually raised in cross-examination, and what we are seeking is a clarification on who RG is.
And Your Honor, I have said, our practice in a hospital to protect privacy, because these documents go around hospitals. The malaria parasite is positive, blah, blah, it's for the one. So we use codes.
Can you just
ask
him who RG is?
RG is the Honorable Rigathi Gachagua.
Okay, is there any other identification information in that document? Have a look. Is there any other identification information with respect to that, without necessarily reading it out?
There's a mobile telephone number also.
Thank you. Would you confirm whether there is any discrepancy between the affidavit and DKG3, the discharge summary?
Not at all.
Thank you. And lastly, is DKRG, what document is DKRG? Because there's been an allegation of a medical report. What is DKRG?
It's a discharge summary.
It's a discharge summary.
It's not a medical report. A medical report gives details that may not necessarily be required by this court. But if required, Your Honor, it's available.
And in your discharge summary, you were confirming what you deponed to in paragraph 11 on the purpose of the affidavit.
Absolutely, Your Honor.
Which is admission, discharge, and treatment.
Absolutely.
Thank you, Your Honor. That's all.
Just one very brief question, Dr. Gikonyo. It was put to you by Dr. Kionkulu that you admitted the petitioner, His Excellency Rigathi Gachagua, to hide him, suggesting he wasn't sick. And I think you responded by laughing. Now that you have finished laughing, will you please answer the question? Was Rigathi Gachagua sick or not sick? Why are you hiding him in your hospital? Please answer. It is a serious question.
I must say I laugh because I thought it was not a serious question, because maybe it is not common sense. But however, the answer is yes, he was sick. We admitted him. We have data that's available to any medical person. We have medical reports. We have traces of his ECG, his echoes, everything, lab data that's available and available on demand by this court.
And apart from the documents, Dr. Gikonyo, you were here as a doctor, head doctor who was treating him.
Your Honor, that's why you called me, to answer those questions.
That's
I'd have
right.
answered to the affirmative. I was the one who was treating him with my team. He was sick. We have data. We have provided an affidavit. If there's any further questions, we will provide it.
That's all, my lords, your leadership.
Thank you, Dr. For coming to clarify those issues. You may now take your seat.
My lords, can Dr. Gikonyo be released as a witness?
I will say that he can take his seat.
Okay.
He can be here or he can go home.
Oh, okay. That is the only clarification I want to make. I don't think you'll be going home, you'll be going back to college.
There's water. There's water. There's water. Is that your water?
Yeah.
Yes, my lords and my lady. Again, we are now in the proper business of submissions, and I am ready to proceed subject to any other direction that you may want to.
What is the kind of directions that you people will be seeking in relation to procedure?
My lord, if it works for the court, we would want to have the remaining part of the day for us as the respondents try and push and possibly conclude our submissions. We also hope that if time allows, we could then have any responses so that the matter is closed today. But I think what we'll be asking for specifically is about, we will not go beyond 8 hours on the outer side.
We're talking about 8 hours and we're talking about concluding today.
Well, you know, we have previously sat up about 10 p.m., but I wanted to get your direction so that we also know how to budget and plan as to when we'll be ending, so that we know which testimonies you take and whether or not you'd want to have us progress with the submissions this morning.
I think, Mr. Bumbo, before we give directions, we probably want to know how many of you will be addressing the court and what directions do you require with respect to the cross-examination that has just happened? Will you follow that up by making oral submissions so that we don't have to take written?
So, my Lord, we will, in the course of making our oral submissions, be also submitting on what has transpired during the cross-examination. So that need not bring any complication. The respondents will deal with the issues in the course of highlighting their written submission.
So that means Mr. Gumbo and...
So, my lady, on behalf of the National Assembly, we will have 4 of us making our submissions. We do not expect to go beyond 2 hours.
Yes, and that is for the National Assembly.
That's for the National Assembly.
Yes, Your Lordship, my lords, on behalf of Senate, I will lead the team and will be on point. Will be assisted by 2 other counsel on other questions. Not more than 2 hours. I think I should take not more than 2.5 hours. I'm normally very brief.
My Lord, on behalf of Professor Kibure Kindiki, we also need 2 hours. We'll be sharing the time with the team that I lead.
On behalf of the Attorney General, I wish to confirm that we do not wish to make any further submissions, as we believe that our submissions were clear and nothing we have heard since we made them has changed that position.
Your Lordship, if I may, on behalf of the 9th respondent, we require about 45 minutes.
My Lord, for the 10th respondents, we'll just do 1 hour.
Okay.
On the part of the commission, will take about 8 minutes.
Which commission?
The ABC. The 16th respondent.
My Lord, may I suggest that perhaps we start with the IBC, which is taking 20 minutes, and then we come to the parties who wish to take longer. And also wonder why my learned friend, Dr. Kiankulu, would require the same amount of time as the primary respondents. He is really an interested party.
I think those submissions were being made on the light of the knowledge that I divided by half. I will certainly will not give you 2 hours. I will not give you 2 hours. I will not give you 2.5 hours. But will give you sufficient time for you to make coherent submissions in this matter.
Our only concern is parity of arms. That side took about 10 hours. 10 hours. So we'll be taking less, even if you add all the times that they took. Yeah, even when you subtract the half, they still took 10 hours.
They did not, but we'll give you sufficient time.
My Lord, for the record, for the Speaker, my Lord, Milimo, my Lord will be taking not more than 30 minutes.
That's 15, that's good. So can we have the person who set the pace, 10 minutes, IEBC?
If it may please you, my Lord, my name is Kipe Mungai. I appear with Mr. Kamwaro and Mr. Peter Koira for the 10th to 41st petitioners. We made our submissions on our petition last Thursday. My Lord, we are here for the simple reason that the following day, on Friday, the Constitutional Court of South Africa rendered a decision with regard to an issue of presidential impeachment that directly deals with part of the issues that was substantially raised on behalf of the first petitioner and by the 10th to 41st petitioners. A judgment that is directly relevant in this matter. Being proactive, yesterday, the 12th of May, we filed supplementary submissions to bring, which we have served all the parties, to bring that issue to the attention of the court, and with a view that the supplementary submissions that we did, the court may certify them as duly filed so that they become part of the record of our submissions, and today, so that to enable the other side to respond, to be able to seek directions of the court on how we should progress based on that issue. We make this request for the simple reason that the Supreme Court, in the case of Sonko, that has been cited severally, indicated that the advocates and all the parties and the court have a responsibility to ensure that cases are decided on the basis of all relevant matters of law and fact and the best research that is possible. So we are under our duty, and we have done something direct, proactively, to certify that duty, that this is a decision that needs to be considered by this court. And the right procedure, if I may be asked, is that I would be requesting that within 30 minutes, I can formally, before they start, because it is a matter they would have a right to respond to summarize what are the issues and brief reasons why that decision should be incorporated and the sense in which it should be understood by this court as part of the petitioner's submissions. I believe in particular the first petitioner, whom Mr. Ochiel said a lot of things about that issue of the Senate and the special committee, would have an interest in that particular matter. So may I request for directions on that issue. It is already filed, the decision is also filed, so that all that would be required would be to hear what would be the best way to proceed before the respondents have started. I believe, in view of the proceedings that have taken place, the petitioners have just closed their case for today. Only that my learned colleague, Professor Rigathi, had made submissions on behalf of the client Attorney General. So that's all.
My lords, we became aware of this decision as soon as it was issued, and this is largely due to my younger learned friend who circulated it, and for which I thank him. It's a very weighty decision from the Constitutional Court of South Africa. It will be our submission. It is totally irrelevant. What I would propose we do, just like my learned friend Mr. Kibe Mungai has done, he has filed his own submissions on it. I would beseech my Lord to open the same path to anybody who wants to submit on it, and we leave it at that. We do not wish further time be expended on this is the court, this is the judgment of a foreign court about foreign law. So it should not detain us, and we should proceed as my Lord has suggested.
That's a sensible suggestion on our side. And you also think that the court can save time for rejoinder by allowing most of the petitioners to make their rejoinder in writing that way, and then the wish to conclude today could be achieved.
Mr. Kibe, you look...
It's just that it is irresistible for the first petitioner not to join issues, Professor Gidu Muigai, that this decision is utterly irrelevant.
It is?
He said, he told this court that the decision is utterly irrelevant.
I thought you were confirming that.
My concern is that there cannot be a more relevant decision on the attempt to avoid a committee of parliament to do the investigation, and on the jurisdiction of the court to question actions and decisions and resolutions of parliament. This decision answers to those two issues, but if everybody gets leave of this court to put in written admissions on that point, then I'm in agreement with senior counsel, Professor Gideon. Thank you.
I knew, my lords, one day before we retire, my learned friend and I will agree on something.
Thank you very much. I think we have more or less agreed that we treat Mr. Kibe's submissions on that issue. We allow parties for submissions on that issue. And between now and then, and the time we retire to write our ruling, if you have an authority, just file it. Just file it, we'll consider it.
Thank you. Auditor, we shall say something about it during the rejoinder.
All right, that is okay.
Thank you.
Yes, IABC.
My Lord, we have Ms. Joy and Mr. Nura. I think the President called.
We will particularly take note of time.
If Your Lordship could give me a second to catch my breath. It's a hassle to get from the back of the court to the front. Pleases my lords, my lady. My name is Nura Abdul Kadir. I appear alongside Ms. Joy, Ms. Faith Kiende, Mr. Derek Asala, and I also hold brief for Mr. Mahat Somani for the 16th respondent to the IEBC. And together with these oral submissions that I will make, the 16th respondent also relies on the submissions he filed. On the 25th of October 2024, 27th of October 2024, and the replying affidavit sworn by the then CEO, Mr. Marjan Hussein Marjan, sworn on the 25th, my Lord, of October 2024. We will be relying on those documents, my Lord. We will briefly highlight on a single issue, my Lord and my lady. And that issue is the IEBC's involvement under Article 149 of the Constitution regarding vacancy of the office of the Deputy President. And the main question that we will be asking is whether the Constitution contemplates any role by the IEBC in the filling of that vacancy. My Lord, Article 49 identifies two actors expressly. That is the President and the National Assembly. Therefore, the question that arises for this court's determination is whether, beyond those two expressly identified individuals, those two expressly identified actors, does the Constitution intend any additional role for any other actor, but for purposes of this submission, the IEBC? My Lord, it is our humble submission that that particular article is deliberately narrow and precise by design. It provides two constitutional actors and two constitutional functions. First, the President, who nominates a person within 14 days. Second, the National Assembly. So on a plain reading, my Lord, of that article, the Constitution does not introduce any third actor, any intermediary, institution, or any additional clearance mechanism where IEBC would play any particular role. And my Lord, in answering this question, and because these submissions have been made severally before this honorable court, is what would have been or what could be the intentions of the drafters of the Constitution. And in asking ourselves this question, my Lord, we interrogated the harmonized draft and the Bomas draft 2004. Under Article 168 of the Bomas draft 2004, my Lord, the process was expressly confined to the President and Parliament. And while this process was a bit more complex than what we have in our present Constitution, involving both houses of Parliament, it still made no mention of the IEBC. When we move closer to the current Constitution that we have in the harmonized draft at Article 170, it is more similar to our Article 149. Again, there was absolutely no mention of any role played by the Electoral Commission at any point. Therefore, both drafts reveal that the drafters of the Constitution, sometimes we belabor too much on what the drafters intended. It could be easier to just reach out to Professor Giriga and ask him what he intended. But it is clear from those two drafts that there was no intention to involve the Electoral Commission. Therefore, we ask ourselves, where could the qualms and the quarrel by the petitioner have arisen against the IEBC? And that would fall on one article of the Constitution. That is Article 148, the qualifications of a Deputy President. If you look at the qualifications of a Deputy President under Article 148, the Constitution references you to the qualifications of a President in 137, which further references you to the qualifications of a Member of Parliament, which is Article 99. My Lord, it is our submission that the petitioners proceed from an assumption that the IEBC must therefore undertake a formal verification or clearance exercise as though the filling of a vacancy under Article 145 were an electoral process, which we humbly submit that it was not. My Lord, it is our humble submission that if there is any role that is not expressly stated or implied under Article 149, it would be to the two actors who have been mentioned in that article. That would be the President and the National Assembly. To satisfy themselves that the nominee meets the constitutional requirements of that office. My Lord, in that context, and seemingly out of abundance of caution, that we submit that the President sought factual information from the IEBC. And the IEBC merely responded with information that was within its custody, whether or not an individual is within the voter register. My Lord, we submit that up to that point, up to the point that the IEBC provided that information, it was not under any constitutional obligation or duty under Article 149. It simply provided information that it possessed. Now, my Lord, the other qualm that the petitioners seem to have is whether the information issued by the IEBC was improperly provided by a commission which was not properly constituted. My Lord, I humbly submit that this particular issue has been heavily argued before courts, and there's several case law that demonstrate the roles played by the IEBC, either by the Secretariat or the Commission, or the Secretariat and the Commission. And we humbly submit one of those very important authorities, which can be found in our digest, is the presidential petition of 2022, E005, Raila Amolo Odinga and others versus the IEBC. My Lord, we submit that in that case, three distinct roles came out clearly. The IEBC possesses a role where the Constitution references, or where the legislation references the Commission. It could mean the Commission and the Secretariat, as was elaborated in that case, with the issue of verification and tallying. So a reference to the Commission could mean the Commission and the Secretariat. The instruction is to the Commission, but the action is to be taken out or to be handled by the Secretariat. And that can be found on paragraph 46 of that decision. And what the second role would be that if legislation or the Constitution references the Commission, it quite simply means the chairperson and the commissioners. And that role is reserved strictly for the chairperson and the commission. And the decision went on to note that there are such roles that can be taken or handled by the Secretariat, such as this one can be submitted. My Lord, from that precedent, two principles clearly emerge from this binding authority. Number one, the Commission acts institutionally, not through personal involvement of the commissioners, in every function. It doesn't act through the commissioners in every single function. And that the Secretariat performs the day-to-day administrative and technical functions. So, my Lord and my Lady, the act that is complained about involves no deliberate decision-making by the Commission. It would not require any decision-making by the Commission. It requires no policy formulation, no exercise of constitutional discretion. It was purely factual and database driven, involving retrieval of information held in the voter register, verification of that information, that indeed the individual whom you sought information from is a registered voter,